Separation of Powers and the Independent Counsel, Morrison v. Olson Revisited. A program planned and developed by the Historical Society of the District of Columbia Circuit with video produced by the Federal Judicial Center. October 28, 2015. Amanda Frost, Professor, American University, Washington College of Law, sets the stage for a reenactment of the arguments in Morrison v. Olson. The Honorable Lawrence H. Silberman, Senior Judge for the U.S. Court of Appeals for the D.C. Circuit, presides over the reenactment. Theodore B. Olson of Gibson, Dunn, and Crutcher argues for the appellant himself, and Catherine E. Stetson of Hogan Lovells argues for the appellee, the independent counsel. Afterward, the Honorable Patricia M. Wald, former judge, U.S. Court of Appeals for the D.C. Circuit, moderates a panel discussion with the program participants. And now setting the stage, Professor Amanda Frost.
Good afternoon. So my role today is to set the stage for this reenactment of the constitutional challenge to the independent counsel provisions of the Ethics in Government Act of 1978. I'm going to begin today by giving you the context and the background for the Ethics in Government Act and telling you a little bit about how the independent counsel provisions worked in practice. Then I'm going to move on to talking about the very specific dispute that led to this case coming before the D.C. Circuit. And then I'm going to walk you through some of the major constitutional issues that were raised by the parties to this case. And finally, I'm going to close by talking about the case's significance, which I hope will also be a topic of discussion in the panel that is to follow the reenactment. So I do see a few younger faces, folks born in the 80s or after, and a few law students, including someone else. So I'm going to try to pitch my remarks at a level where it will help everyone to follow along, including those who are newer to constitutional law. So the Ethics in Government Act of 1978 was a direct response to the Watergate scandal that led to President Nixon's the impeachment proceedings against him and eventually, of course, his resignation. And in particular, it was a response to what's called the Saturday Night Massacre, where the special prosecutor Archibald Cox, who was investigating the Watergate break-in, had asked President Nixon to provide the tapes of discussions in the Oval Office. Nixon resisted, and on Saturday, October 20th, 1973, he ordered his Attorney General to fire Archibald Cox, and of course what followed was a series of resignations and ultimately the termination of the special prosecutor Archibald Cox. This led, of course, to national outrage, to congressional outrage, and as I said, to Nixon's, of course, resignation following impeachment proceedings. So what it showed the nation was that there was a structural flaw in the way that our government did business. That is, that the prosecution, the task of prosecuting, of enforcing the laws, was given to the executive branch, and this creates a conflict of interest when high-level executive branch employees are the very targets of that investigation. So the Ethics in Government Act of 1978 contains several provisions outlining the role of an independent counsel. And for those of you who want to follow along, you get a great one-page sheet provided to you by the D.C. Circuit Historical Society that can be useful to following the discussion that is to come in the oral argument. And in a nutshell, what this act did was it created a special court of Article III judges who, when asked by the Attorney General, who was required to investigate allegations of wrongdoing by high-level executive branch officials, president, vice president, cabinet members, and other high-ranking officials, if the Attorney General then went to the special court and said, I think there's reason for further investigation, the special court's role was to appoint an independent counsel and establish that person's jurisdiction, the scope of the investigation, and who would be targeted. At that point, the independent counsel was to operate as a prosecutor in the Department of Justice. And in fact, that prosecution was to be paid for out of the government funds in the Department of Justice. And the independent counsel was to have all of those resources, including the ability to hire staff, to convene a grand jury, and of course to eventually prosecute if the evidence led to that conclusion. Now, the independent counsel could be removed, but only under very narrow circumstances. So there was the possibility of impeachment and conviction by Congress, but absent that, the only way to remove the independent counsel was to have the Attorney General decide that there was good cause, physical disability, mental incapacity, or any other condition that substantially impairs the performance of that counsel's duties. And even then, although the Attorney General had that power to, for those narrow reasons, remove an independent counsel, even then the counsel could appeal that decision to the special court, which could reverse the Attorney General's decision to terminate the independent counsel if that special court thought that there wasn't reason in fact or law to do so. So I think that provides a good framework for the discussion to follow about this specific case. So what led to this matter coming before the D.C. Circuit? Well, it's either depressing or reassuring to see that for the last 30, 40 years of our country, we've been engaging in the same sort of partisan back and forth disputes. This dispute rose from a democratically controlled Congress who had wanted to get access to some EPA documents involving the EPA's enforcement of Superfund laws. At first, there was a claim of executive privilege by the Reagan administration. Eventually, the documents were turned over, but the House Judiciary Committee investigated that. And the House Judiciary Committee, in the course of that investigation, asked Ted Olson, a high-level, high-ranking employee at the time in the Office of Legal Counsel, to come and testify, and he did so. And following that testimony, following the receipt of the documents in the investigation, the House Judiciary Committee issued a report, sent it to the Attorney General, and they asked the Attorney General to further investigate whether there had been either perjury or obstruction of justice by Ted Olson, Carol Dinkins, and Edward Schmaltz. So the Attorney General did this and eventually went to the special court and asked the special court to appoint an independent counsel to investigate at that point just Ted Olson. That independent counsel, Alexia Morrison, eventually decided to expand the investigation to include Dinkins and Schmaltz, and that decision was upheld by the special court. There had been some dispute about that. So then she issued subpoenas to Olson, Schmaltz, and Dinkins, and all three respond by seeking to quash the subpoenas, and their argument is that the independent counsel statute is unconstitutional. So they made a number of constitutional arguments, and I'll outline them briefly here, again, to help you follow along with the reenactment that you are soon to hear. So the arguments start, I think the first argument to start with here is the Appointments Clause argument. Again, we have our very useful one-page sheet provided by the D.C. Circuit Historical Society, which provides the quotes of the relevant constitutional provisions. And the Appointment Clause challenge was an argument that there are two types of officers that can be appointed under the Constitution in two different ways. Principal officers, the argument goes, have to be appointed by the President with the advice and consent of the Senate. Inferior officers need not be appointed by the President with the involvement of the Senate, but rather can be appointed by the President alone or the courts of law or the heads of departments. So the challengers to the independent counsel statute said that an independent counsel is a principal officer, has to be appointed by the President with the advice and consent of Senate. The independent counsel responded, defended her position by saying, no, I am constitutionally an inferior officer, therefore can be appointed by a court of law. And of course, that turns on what's an inferior officer, what's a principal officer. The Constitution does not speak clearly on that question, but it's very likely you'll hear some debate about what powers the independent counsel has and whether they're sufficiently cabined, whether the independent counsel is sufficiently supervised and restricted in their role such that the independent counsel is an inferior officer, or alternatively that because there's such a broad authority to prosecute with less than complete control and oversight by the executive, that the independent counsel is a principal officer. So that was one major dispute in the case. A related Appointments Clause dispute was even if the independent counsel is indeed an inferior officer, can she be appointed by a court of law? Is that kind of interbranch appointment constitutionally permissible? Maybe courts of law are only supposed to appoint inferior officers within the judicial branch, such as staff attorneys, for example. And so the argument would be the independent counsel is an executive branch officer and so can't be appointed by a court of law. So that question about the interbranch appointment, whether that's permissible, may also be raised today in the reenactment. Moving away from the Appointments Clause, there's also an argument in this case about whether it violates Article 3 of the Constitution, the provision that establishes the federal judiciary. And here the argument is that Federal courts are tasked with deciding cases or controversies. They are not supposed to engage in extrajudicial activities. And here it is, the special court of Article III judges has been assigned the task of appointing an independent counsel, establishing their jurisdiction, and overseeing questions about their removal and termination. So does that violate Article III by giving this court power the Constitution says it shouldn't exercise? And a related point is, does that mean that the courts are jeopardizing individual liberty because they're intimately involved in the operation of the independent counsel statute, and yet they're the very entities that will hear and appeal to the challenge of its constitutionality and will hear legal issues involving the prosecution of the targets of the independent counsel statute. Finally, the last, I think, and probably most important constitutional argument here really is a separation of powers argument, which of course this entire case is a separation of powers case. But this argument turns on the role of the president under Article 2, Section 3 to take care that the laws be faithfully executed. And the argument here is that that's an executive power that can't be taken away from the executive and placed in the hands of another entity. And the argument is that, of course, investigating and prosecuting are inherently executive actions, and yet they've been given to this independent counsel who cannot be terminated by the Attorney General except for under those narrow provisions, the good cause or substantial impairment. And so the argument is if the executive doesn't have the power to fire the independent counsel at will, which of course the executive doesn't, then it is unconstitutional to delegate this purely executive function of executing the law, of investigating and prosecuting under the laws to this independent counsel. And of course, the argument on the other side is this is by necessity. We have the structural flaw. We have a system in which the executive is self-interested when it comes to high-ranking government officials. So we need to give this power to this independent counsel, and there is some executive oversight in that ability of the Attorney General to remove under some narrow circumstances. All right, so I think that's an overview of the issues that you're likely to hear today in our reenactment. But I wanted to say a few words about why we even care anymore. And as many of you know, the independent counsel provision was struck down by the D.C. Circuit 2-1, but then upheld by the Supreme Court in an opinion written by Chief Justice Rehnquist for 7 justices. And of course, then we had, I think it was 11 more years of that law in practice. We saw a number of additional independent counsels, including probably most well-known Ken Starr's investigation of Bill Clinton that ultimately led to impeachment proceedings against President Clinton, and the law was allowed to lapse in 1999. So why are we still talking about it today? Well, first of all, I think that history is very important, and I'm sure will come up in our panel to follow, and how that affects our understanding of the constitutional analysis, if at all. But I would say that this case is important not because of the specific independent counsel provision that was proven in practice not to work very well, I think most would agree, but rather because it's part of a long-standing debate we have about our Constitution and how to approach constitutional problems, particularly in separation of powers cases, but frankly in lots of cases, which is we have this document, hundreds of years old, only a few thousand words, and yet we're expected to have this document govern our nation today, a nation that looks far different than the framers could have envisioned, and we have competing views about what to do about that. And so there's a formalist response that says, let's look at the text, let's look at the framers' intent, let's follow that path because that's the safe and sure and true path, and of course we can amend the Constitution if needed. And then we have a different view, a functionalist view that says, no, when we have a government that has changed so much from what the framers thought, we need to have some play in the joints. We need to look at how the law plays out in practice, and maybe the spirit of the Constitution and its checks and balances is more important to follow by dealing with these structural problems like the self-interested executive unable to prosecute itself. And we should look to that and follow that lead rather than look to the formal parameters of the text or the original intent. So that debate, I don't think we're going to actually resolve today, but I am looking forward to hearing the parties address that both in their arguments and hopefully in the panel after. So like the rest of you, I'm looking forward to watching this reenactment that's to follow. Thanks.
Counsel?
Thank you, Your Honor. May it please the Court. I would like, with the Court's permission, to reserve 2 minutes of my time for rebuttal. Your Honor, the independent counsel provisions of the Ethics in Government Act strike at the heart of the presidency, usurping in multiple ways his ability to perform his explicitly assigned core responsibility under the Constitution's carefully crafted separation of powers. This is not a small or trivial usurpation. The power to investigate and prosecute is the essence of the President's duty faithfully to execute the laws. This statute presumes that the President cannot be trusted to do so. Its purpose is to take that power from him and vest it someplace else because he cannot be trusted to do what the Constitution assigns him to do. In my limited time, I will focus my remarks on four what I perceive as overarching points. First, no political truth was more important to the framers of the Constitution for the preservation of individual liberty than the separation of governmental power, legislative, executive, and judicial. The accumulation of these powers in the hand of one or even many was considered the very definition of tyranny. Secondly, the framers intended executive power to be exercised by a single person. They considered, debated, and decisively rejected the concept of a plural or multiple executive by a vote of 7-3 on June 4, 1787. This is described in detail in Federalist 70. Third, the central role assigned to the unitary executive was the faithful execution of the laws. The core of the duty to faithfully execute the laws is deciding how the laws shall be enforced, in what manner, against whom, and when. The executive has exclusive authority, the Supreme Court decided in United States versus Nixon, exclusive authority and absolute discretion to decide whether to prosecute a case. And point four, the independent counsel statute usurps the president's executive power in multiple destructive ways. First, there is an impossibly low threshold to require the Attorney General to seek a judge to appoint an independent counsel. He must do so unless he can find there is no reasonable basis to further investigate the allegations.
Counsel, you haven't yet gone to the provisions of the statute which you think contradict the principles that you're setting forth.
The provisions of the statute I perceive as, and I think the court should conceive of and consider in total. It's the appointment pursuant to this trigger that I just described, the fact that the prosecutor must be completely independent from the executive, from the Department of Justice.
That's an overstatement, counsel. My recollection of the statute is that the independent counsel should follow the policies of the Justice Department, at least unless they're impossible.
Unless the independent counsel, in the independent counsel's discretion, determines them not to be possible to follow. That's a very elusive and elastic standard, and it's not reviewable. So, and then the targets of the independent counsel statute are the president himself and the persons closest to the president.
Wait a minute, you said it's not reviewable. The Attorney General could discharge the independent counsel if the independent counsel was proceeding in a fashion which the Attorney General thought was grotesquely inappropriate.
The Attorney General could make that decision if the Attorney General wanted to take the political risks of doing so, and then that decision could be in turn overruled by the court. So and there's no standards in the statute with respect to making that determination, Your Honor.
Well, we should consider the political inhibitions here as part of the constitutional...
The political small p implications, this is a political mechanism to take power away from the president because Congress made the assumption that the president, for political reasons, can't be trusted to do what the Constitution vests in him to do, that is to enforce the laws against persons that are a part of his administration. As I said, this is something that not only can be triggered by allegations in a newspaper or something like that, but it can also be triggered by the legislature. The appointment is by the judiciary, which is expected to provide neutrality and independence with respect to someone who is being prosecuted.
Do you think the real problem in this case is that the judiciary appoints a prosecutor?
The real problem in this case is from start to finish, the trigger on the statute, the limitation on the president's discretion, the fact that the Attorney General must seek the appointment of an independent counsel, that the judiciary, the so-called independent judiciary under Article 3, not in making a decision involving a case or controversy, must appoint the independent counsel, supervise the independent counsel, decide the scope of the independent counsel responsibility, and play a hand in the decision as to whether to remove or not. So it's not just the involvement of the judiciary, it's the involvement of the legislature potentially in triggering this statute. This case arose out of a dispute over the president's prerogative to claim...
Excuse me, counsel, I just want to follow up on one point you made. You're familiar with a statute that authorizes federal judges to appoint U.S. attorneys in the event there's a vacancy. You are familiar with that provision?
I am familiar with that.
Is it your view that that's unconstitutional?
I think that there are issues with respect to that and other circumstances where the judiciary is involved, including the settlement of antitrust cases and class actions and
Counsel,
so on.
I'm not sure you answered my question. Do you think it's unconstitutional or not?
I think that it raises constitutional questions, but
we do that all the time.
Not of the magnitude. I want to focus on the totality. It's not just judicial appointment, but it's the supervision of the scope of the responsibility. It's the supervision of how the person performs his responsibility and whether he can be removed or not. And it's the power to trigger the appointment. It's who can be prosecuted. In those circumstances, the prosecutor is being appointed to do this job articulated by the statute. It isn't, in the words of Robert Jackson's famous speech to the United States attorneys in the early 40s, to identify a person who must be prosecuted or investigated. And Robert Jackson, Attorney General Jackson, made the point in that important speech that to investigate embraces the power to destroy an individual for reputational purposes, and the individual's career can be damaged as a result of that. Those provisions to which you were just referring don't have anything like that in terms of identifying who will be prosecuted. Furthermore, the Assistant Attorney General or the U.S. Attorney has limited to the constraints of the Department of Justice.
So, in other words, the appointment power is not that important. You're more concerned about removal, is that correct?
No, I think the appointment power is very, very important because the president, as you know, is given responsibility under the Constitution to take care that the laws are faithfully executed. The president can do that through the power of appointment of the persons who take charge and execute the president's directives.
But in this statute, excuse me, Counsel, the statute I'm referring to authorizes federal judges to appoint U.S. attorneys.
Yes, but those attorneys are in turn
subject to removals. That's why I said I thought your basic argument was removal rather than appointment.
It is not just removal. It's the supervision of the Attorney General. The Attorney General can call the United States Attorney and say, do this, do that, follow this procedure, use your resources in a different way, focus on drug relations or organized crime. The policies and the implementation is the responsibility of the Attorney General. I'm very close to the time that I need to reserve for rebuttal. I urge the court to consider it in this context. It isn't just the appointment. It isn't just the supervision. It isn't just the removal. It isn't just the definition of the jurisdiction of the independent counsel. It isn't just that it's an unlimited time and an unlimited budget. It isn't just any of those things. It is all of those things. The purpose and effect of the statute is to take the president's power over his most important subordinates and take that authority and give it to someone else who is independent. That is inconsistent with the assignment of the executive power to a president.
Thank you, Counsel. Counsel for Morrison.
Thank you, Your Honor, and may it please the Court. The first question that you posed to Mr. Olson identified what I think is the fundamental flaw in his argument. For you to be equipped to decide this case, you need something more than rhetoric. You need text and you need precedent. And you did not hear one mention of precedent in Mr. Olson's presentation. But I'll start with the rhetoric, because I agree with Mr. Olson on this fundamental point, the separation of powers.
Well, wait a minute, counsel. What precedent are you relying on? I haven't, in our research, we didn't find any case squarely at point on appointment authority. Did you have a case that you would like to call to our attention?
We have multiple cases that I would be happy to call to your attention.
One will do.
If I had one that fit this case on all fours, I'd certainly offer it. But the problem here is what Mr. Olson left you with was a suggestion that essentially the constitutional problem, is greater than the sum of its parts. But we need to look at the parts in order to identify the constitutional problem. It's not enough just to stand up and make a holistic
argument. Your basic argument
argument.
is that your client, in this case, Ms. Morrison, is an inferior officer. That is correct, isn't it? And therefore can be appointed by who?
We do contend that Ms. Morrison is an inferior officer, that she can be appointed by the courts, because that is exactly what the text of the statute says.
As I read your brief, however, you take the position that the only principal officers are ambassadors, public ministers, and Supreme Court justices. That's quite an extraordinary argument. That everybody else, including department heads, are inferior officers, according to your brief.
Judge Silberman, I think I would extend beyond the narrow categories identified in the brief, the suggestion that
You're
there are...
You're going to abandon your brief's position then?
I will abandon that brief's position.
I can understand that.
There are naturally other principal officers that are contemplated by the statute.
In other words, you would include department heads are principal officers.
Yes, but on that point, one of the problems I think with questioning whether Ms. Morrison is or is not an inferior officer is that there is no definition that the framers provided us. So what we're left with is to consult with some of the precedents that I mentioned, Germain and others, to ask what are the component part, what constitutes an inferior officer? It can't be enough for an officer merely to be subordinate. Department heads are subordinate to the president. It can't be enough for an inferior officer merely to be limited in time, because cabinet heads can be limited in time. I do think, though, that it is important to look at the scope and the nature of the independent counsel's charge.
Why isn't counsel correct in arguing that the independent counsel is, in some respects, more powerful, more important than the Attorney General, him or herself? Because under the statute, the independent counsel can make an independent determination of whether to prosecute someone against the views of the President of the United States. How can you have anybody more powerful than that?
Judge Silberman, that's not exactly accurate. The Attorney General brings the independent counsel into the world. The Attorney General can take her out of it. The fact that the Attorney General, the power resides in the Attorney General to request the appointment of the independent counsel, to declare that there is a sufficient ground for investigation.
Wait a minute. This is a very troubling point, because if the independent counsel decides that she will prosecute X, and the President of the United States says, prosecuting X jeopardizes the national security of the United States. There are matters that we cannot tolerate. And the independent counsel says, well, the statute gives me authority to do so, notwithstanding your views, Mr. President. Are you saying under those circumstances the Attorney General has an absolute right to remove the independent counsel?
No, but I believe that Your Honor might be overlooking another aspect of the President's power. The President has the pardon power. So even in the circumstance where the President disagrees with the independent counsel's recommendation, even in the circumstance where the Attorney General, left to his own devices, would not pursue the investigation.
Well, suppose the independent counsel wishes to call as a witness someone who the Attorney General and the President of the United States think would jeopardize national security. and the independent counsel states that I absolutely need that witness to make my case, then what? Let's suppose the independent counsel wants to call, for instance, security officials, like Secret Service agents.
Judge Silberman, I think when it comes to the calling of witnesses, there would be two solutions at least. One of them relatively minor and one of them quite radical, but it's available. The minor solution is to simply put in place safeguards against that person's testimony getting out. The major solution, which is available to the president, which is important for this separation powers concept, is the pardon power.
Yeah, but that doesn't help, because the independent counsel is just using, the disagreement is over who's going to testify, not who's going to be a target of the investigation.
Oh, no,
So in other words, the president's the only way he can deal with the problem of the independent counsel calling people as witnesses who the president thinks would jeopardize national security is to pardon the target?
That is the nuclear option that I am suggesting, but it is available to the president. If it is an issue of national security, then the pardon power still resides in the president. There is no aggregation of the executive power to any other branch. And I think that's an important element here. When you listen to Mr. Olson's argument and you read his briefs, there is the suggestion that either the legislature or the judiciary or some unknown fourth branch has arrogated unto itself a power that resides with the executive. The Attorney General seeks the appointment of the independent counsel. The Attorney General decides whether the investigation is warranted. The Attorney General can remove the independent counsel.
Wait, stop. And removal, that's a problem. The Attorney General can remove. Then what happens under the statute? The issue goes, if the independent counsel protests, to the very panel that appointed the independent counsel. And as I read the statute, the panel has authority to overrule the Attorney General on any question of law or fact. That's even more than de novo review. That's a double key, isn't it? Basically, isn't the the Attorney General in a position where he or she has to petition the court to allow the removal of the independent counsel?
Your Honor, there's two issues, I think, packed into that. The first is with respect to the overruling on any question of law or fact. The statutory deficiency, I think, at the time of this argument may or may not have been corrected. But to your greater point,
the statute can't be affected. As it turns out, the statute was changed after the oral argument. But that, of course, can't affect the fact that Mr. Olson was held in contempt under a different statute, can it?
Understood, which leads me to the other removal point.
So you give up on that point, don't you?
For purposes of this reenactment, yes. But that leads us that the question about removal and the question about the constraints on removal lead us to those pesky precedents I mentioned. It already has been made clear from Myers and Humphrey's executor and Weiner and Boucher that there are...
Humphrey's executor's counsel turned on the proposition, which may have been debatable, that the FTC was a quasi-judicial, quasi-legislative body, not a purely executive operation. Everybody concedes in this case that the independent counsel is engaged in purely executive function. Isn't that true?
No, I don't think that's accurate, Judge Silberman. It certainly has been bandied about that there are concepts such as quasi-legislative and quasi-judicial. I think the important element of both Humphrey's executor and Weiner versus United States has to do with the nature of the role that particular official was serving. FTC was designed to be an independent commission, independent of executive influence. The official in Weiner was designed to be an independent actor, independent of executive influence.
But
so
Weiner
the reason, Your Honor,
was a quasi-judicial function.
Yes, but again, the quasi doctrinally, I think,
was a judicial function.
It was described as a quasi-judicial function. Right. But the purpose of the quasi is less important than the actuality, which is that in each of those cases, the actor was designed to be independent. So we're already past the point, given Supreme Court precedents, that we're going to argue about the need sometimes to guard against the incursion of an executive. The Supreme Court for 80 years has held that it is permissible to guard against the incursion of the executive in order to preserve the...
I want to pursue this point of pure executive function. Wouldn't you agree with me that on the Supreme Court, the individual justice who probably has the most sympathy to a functional approach rather than a formalist approach would be Justice White? Would you agree with me on that?
For purposes of this age and time, yes.
Okay. Justice White has repeatedly in Chadha and in Buckley and in Boucher always said that prosecution would be a pure executive function. And that was different from other matters that were before him. But again and again he said that. Isn't that a fair proposition, that prosecution is a pure executive function?
You know, there's two answers. I could quibble with the question whether prosecution is a pure or a core executive function. It's not foreign relations. It's not military. At the time of the framers, the prosecutors were part-time, private, independent contractors. So it's really not, I don't want to accede to the idea that this is a core function. But even if it is...
So you disagree with Justice White?
I do. Oh. But even if it is, for these purposes, the core functionality, again, gets back to the quasi point. The quasi point is not a basis for making a constitutional decision. The point of those prior precedents that I stated to you is that in each of them, there was seen a need to guard against an incursion of the executive branch. That is the great irony of this constitutional challenge. The reason that this solution was devised is that the executive branch was essentially abusing its discretion and refusing to...
I'm not sure this is crucial to anybody's argument, but what puzzles me is the notion that the statute was needed to deal with a major flaw. I witnessed the Watergate situation. The denouement of Watergate is the existing system worked. To be sure, the president directed the firing of Cox, but then because of a political outcry, Jaworski was immediately appointed. So why was this an example of such a terrible problem? If you go back to Teapot Dome, that was resolved in a similar fashion. So where are the situations that indicate this desperate need?
Your Honor, my time is up. Can I answer your question?
Can you please answer that question?
The question whether the system is perceived to have worked, given the chaos after the Saturday Night Massacre, I think is very much an open question. The fact is that Congress identified this as a problem inherent in the separation of powers, and decided to craft a statute that stayed within the limits of the Constitution in order to administer a corrective to that problem. Thank you, Your Honor.
Mr. Olson has time remaining as a courtroom deputy. I'm talking to you, young man. Apparently, yes.
Thank you. I see the clock, Your Honor. I will be brief. My opponent suggests that this statute should be analyzed one little piece at a time, and if each little piece can be justified by some precedent someplace else, the totality of what is being done by this statute is therefore constitutional. That is not how adjudication functions. The Constitution itself was built on a system by individuals who understood that it was going to be implemented by people, and it put in place in the Constitution systems to deal with conflicts of interest. It trusted the president, but it didn't trust the president that much because it gave legislative power to the legislature, it gave impeachment power to the constitutional provisions, it gave separate power to the judiciary. So no part of our government is trusted because the Constitution takes care of those things and as contemplates that.
In other words, you don't want to focus on the specific arguments in your brief. And if you were to focus on, which do you think is your strongest point? Is it appointment? Is it removal? Is it the role of the judiciary? Which is it?
It is the assignment to a unitary president by the Constitution, the power.
Counsel, you're just giving me the general position. I want to know which is your strongest argument here. Is it appointment, removal?
This is not. I think the appointment violates the Constitution, the removal does, the supervision by courts do, the taking away the protection of an individual, of an independent judiciary, because the judiciary is involved in creating that person. But fundamentally, Your Honor, it's the totality of it, and it's not a general proposition. It is a specific proposition. The Constitution says that the executive power shall be invested in a president. This statute at one time expands legislative power, compromises the
Why
judiciary,
is legislative power
and
expanded?
emasculates...
Wait a minute, stop, counsel. Why is legislative power expanded? How did the legislature...
Whenever you reduce the power of the president, you expand the power of the legislature, and this case is a specific example of that, because this was a dispute between the legislature and the president over the invocation of an executive privilege with respect to documents, weakening the president's ability to invoke executive privilege by prosecuting the people who advised him.
Well, you'll concede this is not like voucher or charter, where the Congress maintains a continuing role.
Well, yes, Congress does, because there's a provision in the independent counsel statute that gives oversight to Congress of the independent counsel.
Well, but Congress always has oversight of any part of the executive branch.
Yes, but it's specifically set up here. It allows Congress to trigger the invocation of the independent counsel statute whenever there's a fight between Congress and the presidency. So this does...
No, that's not so, counsel. The Attorney General has to make a preliminary decision. Isn't that correct?
He only has to make a preliminary decision that there's no reason that he can't find a reason not to investigate further. This is an impossibly low threshold, and the courts have specifically said over and over again that it gives the individual Attorney General essentially no discretion at all, and it was intended to give the Attorney General no discretion because the Attorney General and the person he worked for was not to be trusted.
Now, in fact, in this case, the Attorney General determined not to proceed against Dinkins or Schmaltz. Apparently, Olson was thought of as a particularly bad character.
Yeah. That's what happens to someone who occupies the position of Office of Legal Counsel, Your Honor. But you see what happened. We have an investigation of Dinkins and Schmaltz, and because the court expanded that. The one last point I'll make, and I appreciate I'm out of time, the pardon power is not an answer to this at all. The president cannot pardon himself, and it's a political decision that would cause all kinds of difficulties for the president. The Constitution has provided systems to check out-of-control executive branch officials, and that's the impeachment power.
Thank you, counsel.
We're now going to have a discussion about some of the provocative and interesting questions that the oral argument raised, not only in and of itself, but in the context of history and what's happened since. The participants in the discussion, you've already been introduced, and so we'll just consider it a continuation of sorts after the oral argument. Judge Silberman, you're the star of the production, so my first question is going to be leveled at you, and it'll be followed by asking Ms. Stetson the same question so she can be on her alert. I might point out that Ms. Stetson can answer the question either in her public persona as the independent counsel or in her private capacity as a brilliant D.C. lawyer. Okay. The question, Judge Silberman, is, it's been almost 30 years since you wrote the Court of Appeals decision in Morrison v. Olson, in which you held that the independent prosecutor statute was unconstitutional, both under particular parts of the separation of powers framework in the Constitution and cumulatively. Now, in the light of subsequent events, both in the political life of our country and in our jurisprudence, including the Supreme Court's reversal 7-1 of your decision, do you still think you were right in your judgment, and why?
I absolutely think I was right. I remember when the opinion came down from the Supreme Court, I was truly astonished. First of all, there were two things that were, I thought, almost gimmies, absolutely correct. One of which was And of course, you remember Justice Rehnquist's opinion is, in our present considered view, we changed the law on removal, because with both with Myers and Humphreys, the law was, I thought, crystal clear that you couldn't interfere with the president's power or the executive branch's power to remove a pure executive officer unless such an officer was below a policymaking, such as a civil servant. I thought the law was crystal clear on that at the time I wrote the opinion, and it took Justice Rehnquist saying our present considered view is, boom, overturn Humphrey's executor. The second point, which I thought was absolutely crystal clear, which we just alluded to, is the statute as written provided that the panel would review an attempted removal by the president, by the attorney general, and the panel was entitled to disagree with the attorney general on any question of law or fact, which meant it was totally up to the panel as to whether they agreed, because law or fact was everything. And that seemed to me an obvious unconstitutional provision. And the way Justice Rehnquist and the majority of the Supreme Court got around it was to just ignore the fact that the statute was changed after the oral argument, after Ted Olson had been held in contempt. That was ridiculous. When Justice Scalia wrote the dissent, I called him on the phone afterwards and I said, what about this provision giving the panel total authority to review the removal on any question of law or fact? And so help me, Nino said to me, my God, I never got to that issue. There were so many other issues. I forgot about it. So I think on those two questions, it was clear it had to be reversed. Now, of course, I was right on all the other issues, too.
Ms. Stetson, do you have any kind of a different take on that question?
So I am going to answer this question as Ms. Stetson. Okay. And the answer is no, actually, but I think for a different reason. I don't have, as a kind of doctrinal matter, I don't have difficulty with the idea that when you talk about separation of powers, and by the way, Madison didn't have difficulty with this idea. When you talk about separation of powers doesn't mean that the powers are walled off from each other. There are going to be circumstances where there is room for flexion in the joints. Judges appoint prosecutors sometimes to prosecute criminal contempts. Congress can condition removal of certain executive officers. So you see the flexion in the joints there. I think the problem that I have is that if you're going to flirt this closely with a number of significant constitutional issues, you need to do it because of an actual problem. And Judge Silberman's, one of his last questions to me, pointed up my conviction that there was no problem to be solved in this case. The system worked, as Judge Silberman put it, exactly as it was supposed to. After President Nixon ordered Archibald Cox to be fired, and two folks refused, and the third person stepped in and did it, and chaos ensued, we all know what happened next. And the reason that all happened next is because the system worked exactly as it was supposed to. The executive, the unitary executive, was held accountable. So my concern here isn't so much with a constitutional deficiency in the statute. It's that even if we can kind of nudge our way towards agreeing that the statute could be upheld, if you break it into tiny pieces and look at it one by one, which we'll talk about, there has to be a reason, I think, to flirt that closely with that kind of incursion on the separation. That's my problem.
Okay. I'm going to do a slight continuation, starting again with you, Judge Silberman, and then I'll leave you alone for several questions after that. And in this case, I'm going to ask Professor Frost to stay in waiting to give her opinion on it. Judge Silberman, your opinion in the Court of Appeals has been contrasted by some commentators with the Supreme Court's as a more formalistic interpretation of the separation of powers framework. They say you relied on text, dictionary meaning of words, and selected writings of certain framers, whereas the Supreme Court majority took what they called a, quote, more fluid and functional, unquote, approach, asking whether one branch had actually usurped an entire function of another branch, or whether one branch had assumed a core function to the degree that the other branch could not carry out its constitutional role in the balance of powers. Now, these commentators have described Justice Scalia's dissent as having taken a position that no balancing is appropriate at all and that any intrusion upon the executive power is constitutionally verboten. Do you think your approach differed from that advocated by Justice Scalia, and do you agree that there was a formal versus functional distinction in the way your opinion in the Court of Appeals and the Supreme Court's majority opinion was written?
I'm not sure that there's that much difference between Justice Scalia's position and mine. But there was one significant difference, is I felt bound by Supreme Court cases. Of course, Supreme Court justices are never bound by Supreme Court cases. They make it up as they go along. But I thought he did point out that that Humphrey's executor in Myers was being thrown in the ash can. I thought I was following those opinions. Now, with respect to the difference between the functional and formalist approach, I wasn't familiar with this dispute until I got into this case, until the aftermath of this case. Actually, I always thought formalism was just another word for law.
Stetson?
I'll wait in 1 second. First, I apologize for getting your title wrong, and when I spoke about your title at the time of these events, and my defense is that you've held so many high-level positions in government that it's hard to keep track. I wanted to respond by saying what I thought was almost the most interesting part of Judge Silberman's opinion in the D.C. Circuit case was that it was functionalist to some degree, that you talked about what you thought the consequences would be of giving a single person this kind of authority, this kind of unchecked prosecutorial authority without that need to triage and create priorities. And you worried about that runaway prosecutor that I think eventually came to pass. And I'll just point out that's a functionalist strand to the opinion. There certainly was plenty of formalism as well. So in that way, I think your opinion was sort of the complete package. You had problems with this statute across the board.
Is it functionalist to think of the consequences of a constitutional interpretation? I'm not sure. I don't want to go as far as Justice Breyer would go, but I think you're thinking of the consequences of reading a statute as constitutional, as legitimate. Both Justice Scalia and I focused on the fact that with this statute, the independent counsel would attract individuals who had a reason to go after the targets, and we've seen that consistently. But that was part and parcel of the statute, because the statute did not say the independent counsel must follow the policies of the Justice Department. It said the independent counsel should follow the policies of the Justice Department if it's possible, which was open sesame. So I'm not sure that's functionalist. I resent that.
Okay. Mr. Olson, you're up for bat. My question to you is one of realpolitik, as they say. Until 1987, in the Morrison case, there had been some, but not very wide controversy about the independent counsel provisions which came on the heels of Watergate. No offense to you, but the underlying dispute leading to the appointment of an independent counsel in your case was a little bit of an inside Washington EPA congressional committee matter, not as media prone or maybe as popularly gripping the underlying dispute as Watergate, Iran-Contra, or Whitewater. Do you think that the Supreme Court would have reached the same constitutional conclusion if the challenge had arisen in a more politically volatile context like Whitewater or Iran-Contra?
I do. I think that it was easier, it would have been easier for the Supreme Court to decide my case, because my case involved the invocation by the President of an executive privilege, a presidential prerogative that the Supreme Court had approved as a constitutional central role of the President. And my role was to advise the President with respect to his constitutional right to claim executive privilege, and the congressional investigation was of the President's claim of a constitutional right and the advice that he was being given by the Justice Department officials, not just me, but principally me, as to the invocation of his constitutional right. And the argument involving my case, and I don't want to spend a lot of time pleading my case all over again, but that was a question of whether or not I had been candid in a congressional testimony, and it was not under oath, and it was on the record, and there was a transcript of it. It should have taken about 2 weeks to figure out whether or not that was true or not. So this went on, by the time we got to the Supreme Court, 2 or 3 years, and I thought, and I was being obviously ridiculously optimistic about it, but I thought this was an easy case because it was all of those things that I was saying during the argument coming together, and in a context in which it was very difficult to think that there was some threat to the Republic by the Assistant Attorney General for the Office of Legal Counsel giving legal advice to the President of the United States with respect to a constitutional prerogative.
May I add something to that, Pat? You know,
Yeah, sure, go ahead.
I think it was a very hot issue politically at the time. And I think the Supreme Court justices saw it as a hot issue. When I was teaching at Harvard Law School some years ago, I had dinner with 8 Harvard Law professors at Mike Boudin's house, and I gave them the following hypothetical. This was before the attitude had changed considerably in the law schools. So those of us who teach now know that our students overwhelmingly think Justice Scalia was right and Rehnquist wrong. In the first 5 to 10 years, they thought Rehnquist was right. It wasn't until Starr was seen as torturing President Clinton that the attitude changed. But I gave this hypothetical to the Harvard Law professors. I said, suppose in 1949 or 50, Congress had passed, instead of an Ethics in Government Act, a Loyalty in Government Act, after congressional investigations focusing on Alger Hiss, Harry Dexter White, Judith Copeland, all communist agents within the executive branch. And Congress, a Republican Congress, based on the proposition that you couldn't trust the Truman administration to root out communists, passed the Loyalty in Government Act, exact same structure. It was my hypothetical that in 1951 the Supreme Court would have decided 9-0 it was unconstitutional. Every one of the Harvard Law professors agreed with me. Then I said, if you took the present Supreme Court back in history and asked what they would have done, the present Supreme Court, with that hypothetical, would have decided 8-1 it was unconstitutional. And they said, who would have dissented? I said, Rehnquist. He hated communists too much. If I'm right about that, then the politics of the situation had an enormous impact on the Supreme Court. What do you think?
Professor Frost?
Well, I was going to say that I think that context always matters, or at least plays a role at the margins of a case, particularly a case like this. So, I am sure that if a different context had been presented to the court, it's possible it would have resolved the case differently. But I guess what I'll say is that I think what we saw subsequently over the following, 10 plus years, including Ken Starr's investigation, I think that should lead to the conclusion that the Independent Counsel Act was clearly bad policy. But, if we are going to separate out those issues of policy and constitutional law, and they can't be fully separated, of course, but if we're going to separate them at all, I think we can all agree it's bad policy without necessarily agreeing it's unconstitutional.
Okay, let's talk a little bit about the strategies of counsel in arguing their cases in both courts. You had the benefit of seeing one and hearing about the other. Ms. Stetson, as you prepared for your role today, what did you consider your most compelling argument in defending the independent counsel regime? Was that appointment, supervision, jurisdiction, removal? And would your focus have shifted in defending the same statute in the Supreme Court in light of Judge Silberman's Court of Appeals opinion, which was a multifaceted attack upon the Appointments Clause and the lack of executive supervision, limitations, and the criteria for removal?
Well, without having planned it, I think you actually saw from the way that Ted and I argued this what we each thought our most compelling kind of rhetorical package was. If you think about particularly what we now know was the majority decision in Morrison in the Supreme Court, you notice a couple kind of interesting rhetorical contrasts between the majority and the dissent. When it comes to the question of who constitutes an inferior officer, the majority, Justice Rehnquist, essentially kind of throws a whole bunch of concepts together and declares Alexia Morrison inferior. But when it comes to the rest of the constitutional issues, the majority essentially picks each strand and picks it apart and declares each one constitutional, therefore the sum must be constitutional. Justice Scalia, in dissent, dissects the majority's assessment of inferior officer, and then when he gets to the rest of the Constitution, and he goes into some detail about this, but his general rhetorical push is, look at this thing. How could this possibly be constitutional? So what you heard, I think, Ted and me do today was essentially bearing out that rhetorical trick. My approach was essentially to say, as I said to Judge Silberman when I first stood up, you can't just decide this based on heavy rhetoric. You actually need to look at the text, and you need to look at the law, and you need to look at what the Supreme Court has already done in service of massaging around the edges of some of these separation of powers delineations. And once you do that with respect to each of these challenges, at the end of the day, you should agree with us. And then, Ted should speak to what he did, but I think you could tell that Ted took a very different, more holistic approach. So it really is borne out by the character of the opinions as well, I think.
In reverse, Mr. Olson.
Well, you saw what my strategy was today. It was constrained because we had a limited amount of time in oral argument, and I thought it would be better from the standpoint of the entertainment value, such as it is, to approach it in that way. But I nonetheless would have done the same thing had I had a chance to argue it myself at the time. The appointment clause, what is this all about? It is the Congress deciding that the president can't be trusted to perform the thing that was given to the president in Article 2, the faithful execution of the laws. You can't trust the president to do that when it comes to the president himself, or the vice president, any member of the cabinet, the head of the CIA, anybody in the Justice Department, so on and so forth. So we will take that power away from him. So what is that? That's a spear at the heart of Article 2, the separation of powers, and what law enforcement is all about. The restraint on appointment is for the purpose that's a part of the engine to get there. To take away the president's power, you take away his ability to appoint subordinates. And you take away his ability to remove people who aren't doing what the president wants to do as far as executing the law. And then you do all these other things, putting it in the hands of the judiciary, letting Congress trigger it, letting Congress have oversight, restricting all of these things, taking away the judiciary as a neutral party and making it as a part of the process. All of those things are aimed at restricting and taking away the power of the president to do what the framers of the Constitution wanted the president exclusively to have the power to do. So that was my strategy today. That would have been my strategy then, I think.
My hypothetical, if there were a super court and you had another shot at arguing this after both Judge Silberman's opinion in the Court of Appeals and the Supreme Court's opinion, would you change at all your focus?
I would use that approach, but I would say this wolf comes as a wolf.
I think that line's already been.
I think it's a very good one, though.
Yeah, it is. That's it.
I want to say that I was very impressed by counsel for Morrison today, as opposed to the last time, because the one argument presented by Alexis Morrison last time, which I thought was a little silly, was that the only principal officers were the Supreme Court justices and public counsels and ambassadors or ministers. And you gave that away almost immediately, and I think correctly, because that was 90% of her argument on the question of whether or not she was an inferior or a principal officer. She basically said, nobody's a principal officer, not even department heads, except for Supreme Court justices and ambassadors.
As Judge Santel would put it, that's not the hill I wanted to die on today, basically. So.
Okay. Now, some say that Morrison, the case, has played only a minor role in subsequent separation of powers decisions. In fact, in the 1997 Edmunds case, the Supreme Court imposed what looks like a very bright line test for determination of an inferior officer's status over what appeared to be a separate statement, but appeared to be somewhat of a dissent, saying that in fact, the Supreme Court's new test in the Edmunds case, which was a bright line case, was ignoring Morrison as a precedent, and the Supreme Court, Morrison's multi-factor test of duration of appointment, limits on jurisdiction, removal of power. So do you think in that respect, the Supreme Court, Morrison's decision is now a dead letter?
I think it was a ticket good for that train only. The almost ludicrous series of hypotheticals that we used in oral argument, and to a certain extent, in my opinion, Justice Rehnquist just ducked. For instance, I gave if these inter-branch appointments were legal, that is to say, that it was perfectly all right for a court to appoint a prosecutor, then what about an attorney general appointing all the law clerks for the United States Supreme Court? Which was a fun hypothetical at oral argument, or a one judge who happens to be an ex-ambassador appointing all other ambassadors, which he couldn't do ambassadors, they're principal officers, all foreign service officers below the rank of ambassador, which I thought was a nice hypothetical. There are all kinds of these inter-branch appointments, I think, became ridiculous. Justice Rehnquist, the way he dealt with this is we don't have to decide any of those issues. So in other words, it was written as if it was good for this train only. It is our present considered view. This is not so much of an encroachment into the executive branch as to be unconstitutional. It's not clearly wrong. So there were no principles. Fair point?
It's what I call the just this once doctrine, basically. I do agree with that.
How about the other two, Mr. Olson and Professor Frost? How do you feel about that in terms of Morrison's viability?
Professor Frost is going to defend the opinion.
Well, actually, what I was going to say about this question about, Edmunds seems to swing the other way and become a formalist opinion, so is Morrison's functionalist test now a dead letter? I would just say this is, I watched the Supreme Court swing back and forth on its formalist versus functionalist analysis in lots of different areas, especially right now, non-Article III courts, which is a major separation of powers question that the court can't seem to approach consistently and has trouble figuring out which approach to take. So I think I'll just, point out here that this is not unique to this appointments question or inferior principal officer question, and it's a problem that the court struggles with, which interpretive approach to use. And I don't think that because we see it use a formalist approach in one opinion, we can assume that the functionalist approach is dead for all time to come.
Okay. Now, this is for Mr. Olson and Ms. Stetson. Justice Scalia's dissent but mostly for Mr. Olson. Justice Scalia's dissent in the Supreme Court concentrated in part on the, quote, drastic impact that an overly aggressive independent counsel could have on a single individual's life and his or her willingness to serve in the future, the government. Now, Mr. Olson, your experience as an executive branch defendant in the 1980s, when all of this occurred, did not dissuade you from becoming a prominent senior executive branch official in the 2000s. So were the concerns in that respect of Justice Scalia overblown?
No, if the independent counsel statute had still been there when I was appointed to be Solicitor General, I would have thought very, very seriously about doing it, because the other good thing about the Solicitor General is the Solicitor General does not testify before congressional committees. So that's a good part of it. I might have taken that into consideration. But I was very serious about the fact that it's an instrument, the independent counsel, and I spent years involved in the independent counsel statute representing Ronald Reagan in his years post after he left office in the whole Iran-Contra investigation by Judge Walsh, and I saw what I could go on and on and on about with respect to abuses of what I perceived as abuses of the process. The independent counsel statute, when I was going through it, I was trying to practice law. At the same time, I was being investigated by this endless process that seemed to me to go on forever. The independent counsel had a staff of 7 or 8 lawyers and 6 or 7 FBI agents and things like that, and every time I got a telephone call, I didn't know what was going to happen next. The aphorism that a prosecutor can indict a ham sandwich was very much in my mind. I didn't think of myself as a ham sandwich, but I thought that I could be indicted at any time. I'd have to defend myself. If I was indicted, I could never apply for the recovery of my attorney's fees. If I was indicted as a lawyer, I was probably finished, or at least finished for a substantial period of time in terms of practicing law. So if you are in the executive branch and you are at that point of friction, which the Federalist Papers talks in great detail about the impetuous vortex of Congress fighting the president over control of the functions of the EPA or the State Department, the Justice Department, the Treasury Department, whatever it might be, and you can be subpoenaed, and then you could be subject to it was a 2-year investigation by a congressional staff before this independent counsel was appointed. If you can be subjected to that, you've got to be crazy to take those kind of jobs. What in the world would motivate you to do it? So this statute was used as a political weapon by both political parties. It's not peculiar to Democrats or Republicans. It's a weapon, if you give it that power to Congress to put executive branch officials in that box. They have to be crazy to take the job. I didn't have to worry about that by the time 2001 came along. And as I said, the Solicitor General doesn't go anywhere near Congress. Just on the way to the Supreme Court, the Justice Department car goes around to the back of the Supreme Court, so it doesn't have to go right past the front of Congress.
Anybody else up on the panel have a view on this?
I think Ted's practical reaction is far more important than my speculation. I do think that this is one of those questions that is really impossible to answer without being burdened by the history that occurred after this opinion issued, because it is true that both parties essentially weaponized this statute. I do think that the practical considerations that Justice Scalia laid forth, of course, can't thoroughly drive the constitutional analysis. But the reason I say, and you can think about circumstances that are fully tolerable, where an intemperate, federal district judge, not that they exist, could appoint a prosecutor to pursue criminal contempt charges against an attorney, who he finds vexing. That could happen, and that could ruin that attorney's life for a period of years. So the practical realities of that are not, I think, unique to this particular circumstance. It does, though, and this is the way I think Justice Scalia used it, it does show the danger in vesting in the independent counsel the authority to essentially pursue one end at all costs, without regard to resources, without regard to the practicalities of the rest of the department, all of the other, not so much institutional, but practical checks on a prosecutor running rogue.
Let me ask you a follow-up question along those lines, and that is, that we no longer have a special prosecutor, independent prosecutor statute, but we do have had many occasions where we have seen overreaching and abuse by ordinary prosecutors, be they state or be they federal. So do you really think that the leveling of so much emphasis on the possibility of abuse by the special prosecutor is really proportionate, considering that, we have lots of abuses by the ordinary prosecutors?
Let me answer that, if I will. I was thinking, as both my colleagues were discussing, my personal view of the abuses of the independent counsel focused particularly on Walsh, who I thought was horrendous. For one thing, he brought, you remember, the indictment against Weinberger just before the election. Just before, it was the election of George H.W. Bush. I don't think a Democratic administration would have ever done that. There are certain restraints on political officials in the government that aren't applicable to independent counsels who can be partisan as hell but operate below the surface in that respect. That case was brought by my good friend and partner, Jim Brosnahan, working for Walsh. Jim Brosnahan was the most passionate liberal Democrat I knew. He hated the Republicans. And that case brought against Weinberger just before the election, I think, had a political motivation. I don't think a Democratic administration would have done that. So I do think, and everybody on Walsh's staff were passionate liberal Democrats who hated the Reagan administration. For that matter, although Walsh was a Republican, I knew personally from my prior dealings with him that he had enormous distaste for Reagan.
I will say this, that I mentioned the Robert Jackson speech. The danger, the prosecutor is the most powerful person in the United States. That's what he said. That's how he started that speech. He was addressing the United States attorneys, and he was saying, therefore, you must use this power very carefully. You must not pick the person and then find the crime to prosecute, because you can find something in everybody's life that you might decide to prosecute. The independent counsel statute does precisely that. It gives the fishing license or the hunting license to an individual. This is your target. You are now appointed to investigate, and if you decide to do so, prosecute that person. So there's a tremendous motivation by intuitive motivation, human nature. If you've been given the fishing license or the hunting license to go bring back that particular person, you're going to go everywhere. One independent counsel who I was just speaking to the other day stopped and said, I'm not going to listen to any more stuff coming over the transom, because the independent counsel will get that stuff all of the time and keep going, because there's a motivation there. If you find out, you stop your investigation, you don't do anything, and 2 weeks later something comes in that you are going to be subject to big criticism because you stopped. So there's a tendency to go on and on. You're not constrained by the allocation of the resources of the Department of Justice. You don't have to go to the Solicitor General to appeal a case. You don't have to do any of those institutional checks on the power of prosecutors in the Department of Justice. And you can go on and spend as much money and hire as many people as you want, and you can become somewhat famous in doing this sort of thing. So I think, yes, there are abusive prosecutors, but we have systems to deal with them, and the independent judiciary is part of that process. Nothing's perfect. But it's vastly better when you have the institutional checks of the Justice Department and the rules imposed on prosecutors.
Okay, just got about 2 questions left. The first one will be for Professor Frost and Ms. Stetson, and that is that both Judge Silberman's opinion and Judge Scalia's dissent disputed the, quote, necessity for this kind of independent counsel, stating that the constitutional remedy of impeachment of high government officials is adequate to vindicate and deter executive malfeasance, whether or not they're guilty of it or their subordinates down the line are guilty of that. What do you think about this assessment? Start with you.
I was very affected, Judge Silberman, by the part of your opinion, and I hope you won't resent me bringing it up, because I thought it was one of the strongest points, where you said, look, Watergate was a terrible national crisis, a long national nightmare, but we are fools to think that we can pass this statute and thereby avoid going through the painful moments that we suffered in that crisis. And I think that is where Congress went wrong, that impeachment is a remedy that is an extraordinary and painful and difficult thing to go through, but we're wrong to think that we can replace that with something else that will be less painful. So I guess I'm conceding that I think impeachment serves the same purpose.
I completely agree with that. As I said earlier, I think that the statute ended up being, the congressional equivalent of fighting the last war, and there wasn't a reason to do it.
Okay, this last question is probably a throwaway, but I'm going to ask it anyway, and any of you can answer who wishes. In 1994, 7 years after Morrison, President Clinton supported the reauthorization of the law, stating, quote, "This new statute," it had gone through some minor amendments, "enables the great work of government to go forward. This is a good bill, good for the American people and good for their confidence in our democracy." In the latter half of the 90s, President Clinton's views changed, or we can assume they changed, and the statute was not authorized in 1999. Was that a mistake? I think I know the answer, but I'd love to hear you.
I would turn you to Shakespeare. Hoist on your own petard.
The statute had expired.
Yes, I remember.
In the first part of the Clinton administration, and they were advocating that it be reauthorized. Exactly. I called people in the Justice Department. I said, "You have got to be out of your mind. Let it die. Let it be dead. Don't do this to yourself." And I think there were some people in the Justice Department that agreed, and for political reasons, I think that's why President Clinton came out and said, yes, it's a good law, and Janet Reno did. President Clinton subsequently said that was a mistake. He actually said so, of course, after practically everybody in his cabinet and himself became subject to independent counsel statutes and so forth. But they had their chance. They had to persuade Democratic members of Congress to go ahead and reauthorize the independent counsel statute. And as Judge Silberman said, hoist on their own petard.
Well, I think that's about it. Our time is up. I think we've got a definitive answer. Thank you very much.